Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 164. I'm glad we're back to normal. Well, almost normal. This week we're going to look at two cases and both of them are employment tribunal cases. And both of them deal with philosophical beliefs. I thought it'd be worth spending a little bit more time on both the cases, partly because, having been involved in reading and studying about employment law since Whisper It Soft 1982, I still find the subject endlessly fascinating. Both cases deal with an issue which is a fault line, I think, in current society. A conflict of rights which individuals have. It's my right to hold and express an opinion that you disagree utterly with. Do I have the right to make you listen? Do you have the right to make me not express my opinion? Please don't forget podcasts available as iTunes, the Mayer Brown website, YouTube, Spotify, Yahoo, Google Play, Twitter, of course. So, Forstater and CGD, Europe and others. This is an employment tribunal case which was decided on the 18th December 29, and there's been a certain amount of commentary about it. To be honest, I did think long and hard about whether or not to talk about this case on the podcast. Because if ever there is a case which demonstrates the maxim that fools rush in where angels fear to tread, it's probably this case. I also think the great danger of this case is that one's reaction to the outcome of the case is largely coloured by the underlying beliefs which are in debate, rather than by the legal analysis of the decision itself. And the job of the podcast, of course, is to try and focus on the legal analysis and where this might take employers and employees. Let's see how I do. The judgment is a lengthy one. It's very carefully reasoned by Judge Taylor. Both sides were represented by counsel in a hearing that lasted over quite a number of days. So I think it's safe to assume the issues were well chewed over. In the circumstances, my disagreement with some of the conclusions is done with the greatest of respect. The respondent is the Centre for Global Development, and the first respondent is its European arm of that body. The claimant has been a visiting fellow and then entered into a series, I think, of consultancy arrangements with the respondent, but starting in January 2015, and the final one came to an end 3 years later. The claimant's case, which has not yet been tested factually, of course, is that the relationship was ended because the respondent refused to continue it because of her expressions publicly of a philosophical belief. The claimant contends that she was subjected to direct discrimination because of her philosophical beliefs or had suffered indirect sex discrimination as her particular view, forming the relevant belief, was more likely to be held by women than men. What is that view? Well, we'll go through this in more detail, but in brief, the claimant's view is that sex is immutable, whatever a person's stated gender identity or gender expression. You can see now why this case is potentially on the fault line between advocates concerned about protecting women's rights, leaving aside the definition of women for a second, and those who are interested in protecting the rights of transgender people. The tribunal claim was started in March 2019, and in July 2019 a preliminary hearing was set up to determine a number of, astonishingly enough, preliminary issues. Relevant for our purposes was whether the claimant's belief, as pleaded in her particulars of claim, amounted to a philosophical belief capable of being protected under the Equality Act. That belief was stated to be that, quote, the claimant believes, quote, sex is a material reality which should not be conflicted with gender or gender identity. Being female is an immutable biological fact, not a feeling or an identity. Moreover, sex matters. It is important to be able to talk about it and take action against the discrimination, violence and oppression that still affect women and girls because they are born female. Unquote. Claim was also put forward as a lack of belief claim on the part of the claimant. I'll come back to that in a second, but the alternative lack of belief argument was that what she did not believe in was, quote, some people believe that everyone has an inner gender which may be the same as or different to their sex at birth, and that gender effectively trumps sex, so that trans men are men and trans women are women. Typically, such proponents believe that trans women are women from the moment they identify as women, if not before. Unquote. Judge Taylor raised a concern as to whether this was an appropriate preliminary issue, given that, in his opinion, there was a potential overlap between the question as to whether the claimant held a philosophical belief and whether that philosophical belief was the reason for any adverse treatment, as opposed to manifestation of the belief or treatment by her of others that might be said to constitute harassment. This is a particularly significant overlap between identification of belief and the causation question on whether holding the belief was the reason for detrimental treatment. For reasons we'll come on to, I think his caution was fully justified. There are extensive extracts in the tribunal judgment indicating the difficulties faced by both women and transgender people, and some truly depressing statistics on the prejudice suffered. So it's clear there are real challenges here which need to be faced and need to be addressed constructively. Doesn't make the case any easier, however. The claimant is a researcher, a writer on topics related to public policy, tax and business. She's a frequent poster on social media, and she asserted that she became concerned about changes to the Gender Recognition Act in 2017 because of proposals to allow people to self-identify their gender. The claimant, for example, tweeted in September 2018 that she shared concerns that radically expanding the legal definition of women so that it includes both males and females makes it, quote, a meaningless concept and will undermine women's rights and protections, unquote. There appears to have been a certain number of controversial or contentious exchanges between the claimant and others online about alleged misgendering of transgender people by her. In the course of that, she said, amongst other statements, quote, I reserve the right to use the pronouns he and him to refer to male people. While I may choose to use alternative pronouns as a courtesy, no one has a right to compel others to make statements that they do not believe. I think it is important that people are able to refer to the sex of other people accurately and without hesitation, shame or censure, unquote. In a witness statement, she said, quote, I do not believe it is incompatible to recognise that human beings cannot change sex, whilst also protecting the human rights of persons who identify as transgender, unquote. So let's turn and look at the law. Obviously, starting point is Section 13 of the Equality Act 2010, which prohibits direct discrimination if a person, A, discriminates against another, B, because of a protected characteristic, which means that A treats B less favourably than A treats or would treat others. The definition of protected characteristic, Section 4, includes, quote, religion or belief, and Section 10 says that the definition of religion or belief is, religion means any religion when a reference to religion and a reference to religion includes a reference to a lack of religion. Belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief, unquote. Obviously in this area, Article 9 of the European Convention on Human Rights is relevant, and the general right to freedom of thought, conscience and religion, and to manifest that religion or belief, subject only to such limitations as are prescribed by law and are necessary in a democratic society, e.g. for the protection of the rights and freedoms of others. Article 10 also gives the right to freedom of expression, which again is subject to such limitations as prescribed by law and as are necessary in a democratic society for the protection of the reputation or rights of others. As we all know, the Granger case sets out the test for what amounts to a philosophical belief. It's a belief which must be genuinely held. It must be a belief and not opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a level of cogency, seriousness, cohesion and importance. And it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. Tribunals have been advised not to set the Granger criteria, the barrier, too high. For example, whether a belief is genuinely held, it's really a question of whether the belief is held in good faith. In deciding whether or not a belief attains a level of cogency, seriousness, cohesion and importance, tribunals are told, don't set the threshold too high. You get the point. Well, one of the interesting points in this case is around the test for lack of belief and how that's defined. Both parties, according to the tribunal, apparently approached this case on the basis that the Granger criteria applied equally to a test in whether someone had a belief or had a lack of belief in something. Remember, the claimant had framed her case as a positive belief in sex being immutable and a lack of belief that people could self-identify. The tribunal commented that the lack of belief test in accordance with Granger, worked relatively well with religion or lack of religion, but worked less well with a philosophical lack of belief or a lack of philosophical belief. The judge says he comes down generally in favour of deciding the Granger criteria should be applied to a lack of belief claim too. And this is the first of the points where I think I'd have taken a different approach. The judge gives the example that someone holding a religious or philosophical belief that murder is wrong can be tested by the Granger criteria. True enough. However, an absence in a belief that murder is wrong should also be judged by the Granger criteria, otherwise, the judge said, this would lead to a surprising outcome. I think the outcome is an extreme one, the example is an extreme one, and it would in any event fail to be worthy of protection. But take instead the facts of the next case, whether ethical veganism is a protected belief. If one imagines the unlikely scenario that the ethical vegan society, if such a society exists, discriminates against someone who is not a vegan because they're not a vegan, they may not be a vegan because they've never considered the matter. How is that consistent with the Granger criteria? The test for a lack of belief, if the test for the lack of belief requires the same level of cogency and seriousness of thought as a belief test, then the philosophical belief rules will apply to zealots and believers only on either side of a debate. Those who think the issue is unimportant and live their life on that basis, and who genuinely have just a lack of belief, could be discriminated against safely. That would, to me, be quite a troubling conclusion. I do acknowledge, of course, that someone who has a lack of belief in something because they've never thought about it is less likely to face discrimination than someone who is a militant non-believer, if I can put it in those terms. But that's a different question. That's causation. Has actually someone suffered an adverse detriment? It doesn't go to whether or not the lack of belief should be judged by the full Granger criteria. Anyway, the tribunal went through the analysis according to the Granger test and applied it to her belief, and decided that the claimant's belief was that sex is biologically immutable, as I said. The claimant did not accept in any circumstances a trans woman is in reality a woman or a trans man is a man. The tribunal accepted that the claimant's belief went to substantial aspects of human life and behaviour. The tribunal commented that the claimant's concerns, such as ensuring protection of vulnerable women, did not rest on a belief that biological sex is immutable. The tribunal was the view that it was possible to accept that trans women are women, but still argue in certain circumstances you'd be justified to exclude certain trans women from certain spaces that are generally open to women assigned female at birth. They said that this course of action might be lawful under the Equality Act, where it is a proportionate means of achieving a legitimate aim. However, again, I think the tribunal is focused on the detail at the expense of the wider picture. First of all, the examples given by the claimant, and which seem to receive some acknowledgement in the tribunal decision as problematic and difficult, are all based clearly on her belief that there are women assigned at birth and there are trans women, and they're not the same. If she believed differently, i.e. that trans women were identical in all respects to women that are assigned female at birth, the question of safety wouldn't arise. It only arises because there is a difference in her views. Second, to say a proportionate means of achieving legitimate aim could be applied doesn't deal with the issues of direct discrimination. I think what the court is doing is conflating the issue of the claimant's belief with the problems she has specifically identified if her views are not accepted. Tribunal also accepted that the belief had a level of cogency and coherence, although the tribunal make it clear that the judge did not agree with the claimant's actual views. But, and this is the kicker, the tribunal said the claimant's view, in its absolutist nature, was incompatible with human dignity and the fundamental rights of others. Quote, if a person has transitioned from male to female and has a gender recognition certificate, that person is legally a woman. That is not something the claimant is entitled to ignore. Unquote. To ward off the obvious criticism, the tribunal said there was nothing to stop the claimant campaigning against a proposed revision to the Gender Recognition Act to be based more on against a proposed revision that the Gender Recognition Act is going to be based more on self-identification. She's entitled to put forward her view that there should be some spaces that are limited to women assigned female at birth and where it is a proportionate means of achieving a legitimate aim. That does not mean her view is a protected belief for the purposes of the Equality Act. In short, the claimant can legitimately put forward her arguments about the importance of some spaces without insisting, quote, on calling trans women men, unquote. According to the tribunal, people cannot expect to be protected if their core belief involves violating others' dignity and or creating an intimidating, hostile, degrading, humiliating or offensive environment from them. And, of course, that much is uncontroversial. The tribunal went on to say, quote, if part of the belief necessarily, key word, necessarily will result in the violation or dignity of others, that is a component of the belief rather than something separate, unquote. The tribunal noted that as a matter of courtesy, the claimant said she would use the preferred pronouns that a trans woman or trans man wished to have applied to them, but will reserve the right to say that the trans women or trans men are women or men respectively, and that woman means adult human female. Quote, these statements are true and I will continue to say them, unquote, according to the tribunal's note on her evidence. And this, I think, is the very difficult aspect of the case. What the tribunal seems to be saying is she's entitled to a belief. It's not protected under the Equality Act 2010. Surely the logical distinction is between her belief, sex is immutable, and whether she chooses to use offensive terms, i.e. misgendering a transgendered individual, which is a manifestation of that belief. If the position was, and I'm not saying this is necessarily borne out on the facts, that she always used the correct terms to people as a matter of courtesy, why is it a belief outside the scope of protection if she said, I will do it as a matter of courtesy, but I have a right not to do so? That's not a case of necessarily harassing and offending others. Why is it lawful for her to argue for protected spaces for women assigned at birth, which is dependent on the perceived difference between transgendered men and women on the one hand, and gender assigned at birth, men and women, on the other? It's not the belief that is inappropriate. It would seem to be the manifestation of that belief if she is violating the dignity of others, if that is what indeed is happening. In this case, although the court was referred to the so-called gay cake case, Lee and Asher's, they differentiated. I consider that requiring the claimant to refer to the trans woman as a woman is justified to avoid harassment of that person. Similarly, I do not accept that it is a failure to engage the importance of the claimant's qualified right to freedom of expression. That is, a legitimate excluded belief it is legitimate to exclude a belief that necessarily harms the right of others. Unquote. But again, isn't this a circular argument? If the claimant's belief that sex is immutable, that she would, as a matter of practice, choose to treat individual people with courtesy and respect, and in a non-harassing fashion, why is that belief necessarily harming anyone? Isn't it the difference between I believe transgender women are actually men, and the way I treat an individual with courtesy and respect? Putting it all together, it'll be very interesting to see this case goes further. It's an example of the nightmare scenario for employers, of course, a case where the legitimate and democratic rights of individuals just full-on conflict. On the one hand, you have a lawful and democratic right of individuals to live their lives free of harassment and persecution, and with due respect for their protected status. That applies both to rights of women assigned at birth and transgendered men and women. Society allows the rights of people to dissent from orthodoxy and express contrary views, and it's really the conflict between the two of these that is the heart of the case. Can an individual in effect say the 2017 Gender Recognition Act is wrong because it is based on a mistaken view of facts? If they can say that, how different was what the claimant was saying here? As I said at the start, I think a lot of people's reaction to this case will depend where you stand on the underlying debate itself, rather than the right of the employer to dismiss someone, if that's what happened here, for holding views that are contrary to the orthodoxy. So what should an employer do if faced with this sort of issue? Well, clearly a hefty dollop of common sense and compassion on all sides is needed. Equally, a lot of the damaging exchanges appeared on social media, where matters, as we know, can get very heated very quickly. If an employer is faced with a situation within the workplace where the right to express views is conflicting with the rights of others not to be offended by those views, then I think an employer has to work very hard to avoid being put in a situation where it actively has to choose one side or another. In my experience, those sort of irreconcilable circumstances are very rare, but a poor employer caught up in something could yet find itself between a rock and a very hard place. So, next up, Costa and League Against Cruel Sports. By contrast, this is an employment tribunal case on philosophical belief, which is, I think, entirely obvious from start to finish. But since it got a lot of publicity and also forms a useful bookend to the other case, I thought we'd cover them both off at the same time. The background to this is that it's a preliminary hearing to decide whether ethical veganism was a philosophical belief and thus a protected characteristic under the Equality Act 2010. I won't go through the same legal background because we covered all of that off in the previous case. Obviously, the tribunal went through the Granger case and the various factors, and one of the oddities of the case was that the respondents conceded that ethical veganism was a protected characteristic, and it was the tribunal that insisted on a preliminary hearing to consider the issue. The background is that the claimant is a qualified zoologist who became a vegan in 2000 when he transferred completely to a vegan diet immediately. There are a number of paragraphs in the tribunal decision explaining the background to the philosophical belief, but also, and interestingly, the way in which the claimant manifested his belief, which certainly seems to be very comprehensive if you come to read the original decision. But one that I'd never thought of was that the claimant wouldn't live with any companion animal since becoming a vegan. The tribunal had little difficulty in deciding that the belief was genuinely held, that it was a belief, not a viewpoint, and that this related to a weighty and substantial aspect of human life and behaviour. The tribunal also accepted it was clearly worthy of respect and that it had a high level of cogency, cohesion and importance. And on this basis, the tribunal said it was, quote, easy, unquote, to conclude that there was overwhelming evidence that ethical veganism is capable of being a philosophical belief and thus a protected characteristic. And the remaining issues in the hearing are going to be dealt with at a full hearing, which I see from the report is due to be on the 24th of February. Obviously, we don't know the underlying facts of the case and the circumstances in which it is said that the League Against Cruel Sports discriminated against an ethical vegan. So we'll see. Certainly, I think if you asked most employment lawyers, ethical veganism would clearly be something that was a protected philosophical belief. It did, however, make me wonder about the reference, and it's repeated throughout the tribunal decision, to ethical veganism. I totally understand that whether or not an individual adheres to a philosophical belief is a relevant part of the inquiry as to whether or not the claimant is protected. Equally, though, it does seem to lay quite a stock on the individual's reasons for becoming a vegan. What would the position be if someone became a vegan purely because their partner was a vegan? What about someone who's a vegan because, in general terms, they share the ideals, but it's important to them to live a healthy lifestyle and perhaps lose weight? Perhaps more importantly, how is an employer to deal with all of this when faced with someone making claims about protected status? Now, I think the reality may be that individuals who are fervent believers in, let's say, veganism might be more likely to bring a claim if they feel those interests have been compromised in some way or they've suffered a detriment. But it might also be easy for them to show the causative link to the alleged detriment. It's obviously difficult to imagine the circumstances where someone who's a vegan for, let us say, the purpose of losing weight would have any evidence to indicate they might be discriminated against on that ground. Anyway, as I say, both cases are at the cutting edge of this particular flaw in this fault line in society, and I do think the court's development of what amounts effectively to protected beliefs and how we're going to distinguish between manifestation of those beliefs and the underlying belief is going to be very important. Well, thank you very much for listening. I hope you found both the case updates useful. We will be back to 3 cases in the next podcast, I'm sure. And as always, it only remains for me to confirm that no lawyers or animals were harmed in the making of this podcast. Thanks very much for listening.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.